for your life.
Okay, good morning. It is March 26th at Senate Judiciary. We're taking up H744. We don't have a quorum, so we're not going to make any policy suggestions or make any changes, but we do have the sponsor of the bill to provide some background on what it does and why it's being proposed. So I was wondering if this needs to be.
So the joint Rules Committee, Judicial Rules Committee, received a proposal to amend Rule 3, specifically subsection K of Rule 3, relating to what happens after an arrest, that the law enforcement has to contact the court officer, so a judge, to determine whether to release or hold the person, and they will presumably talk about what the underlying events were. And the legislature, I think something like 6-7 years ago, amended that provision to say that the law enforcement officer had to also provide what charges that the law enforcement would make, which it took us a while to get to the point of fixing that error, because that is an error, because law enforcement doesn't charge people. That's what prosecutors do. So in fixing that error, my understanding, and Judge Treadwell can correct me if I'm wrong about my understanding, the Criminal Rules Committee for the courts, the advisory committee on criminal rules, looked at that section, struck that language, but then added additional language that stated that the prosecutors shall provide what their charges are, and also may provide additional information regarding whether bail should be set, what conditions there should be, whether this should be held without bail. So that this usually happens after hours, so law enforcement would call the court. This change would also then require the prosecutor to be involved to explain what the charges would be, and whether they're going to be held overnight or over the weekend, because usually the next day they are actually in front of the judge, and the charges may change by then. The prosecutors may have changed their mind as far as what the charge should be. In any event, there was a lot of pushback on that rule change, and that was, I've been on the Rules Committee for 12 years, and this is the first time that there was significant controversy. The BSEA, state attorneys, deputy state's attorneys, essentially explained that this would be really difficult for them to implement, and that things were working fine as it is. So the Rules Committee, we decided actually to punt it to the legislatures, in part because we initially made that error back 6-7 years ago when we said that law enforcement could charge people. So we thought we could fix that, and we also added the additional language, but we did it a little bit different. We said that the court may require, rather than shall require, prosecutors to say what the charge is. And essentially, we really felt from some of the testimony that we received that this was reflecting current practice. It was codifying, essentially codifying current practice, and wouldn't cause the same upheaval that the underlying rule would cause. So that's what it's a relatively straightforward what we've done here, but I know that Judge Treadwell probably has a different viewpoint of this, and definitely I suggest you hear from a representative of the PSEA and deputy state's attorneys, just to hear their side of that. We are allowed to either the legislature or the courts can change certain rules. There are rules that involve core functions of the courts that we try to avoid messing around with, but this particular rule has been changed by the legislature and the courts numerous times over the years. So this is really a rule that we have as much authority to change the rule as does the courts. I'm happy to answer any questions.
So just to distill it down a bit, the proposed change, so if this were to be implemented in a court, then what would be required of a police officer would be for them to tell the court officer about the conditions of release and any orders to hold without bail potentially, or
Not necessarily.
so it would be the officer then talking to the state's attorneys first, and then just run through the order of operations.
It would depend. I mean, it would depend. My understanding is it depends. It would depend on the judge. It would depend on the relationship the judge might have with particular law enforcement officers that they've had a long relationship with. It depends on what the underlying case or the underlying alleged offense was. I mean, there's a lot of things that it depends. And let me also make very clear that judges can and do individually decide that I want to hear from the prosecutor on every overnight case. If the judge, or if a particular judge is on call, they can decide that they need to hear from the prosecutor. So, but it also gives the flexibility that there may be certain, like I say, certain situations or certain individuals that they've dealt with that they don't need all that information, and that's why it says may. And the same thing, I mean, the underlying rule, the only place where it said shall is that the prosecutors shall, I mean, the rule that was proposed, I should say, from the criminal advisory committee on criminal rules had to do with the charges. It was still a may for additions of release, bail, or bail.
Maybe any questions for Representative Lobo? There.
A quick one is getting back to the order and how things happen. So back in the day, when law enforcement officers would pick somebody up, they didn't necessarily contact the state's attorney's office. It didn't bill necessarily required to do that now.
Depends on what the judge for the particular unit, the particular court decides. I mean, whether they want the law enforcement to always contact the prosecutor, or if there's certain types of offenses that they may not need to contact the prosecutor. So there's some flexibility. And again, I think from what I understand, it's pretty much that's how it works right now. And this really just codifies it.
Mark, sorry, I think I know how to phrase the question I want to ask here. So I guess I'm curious about if any questions came up about attorney work product being put into affidavits that are presented to the court prior to the prosecutor formally asking for a certain condition or hold somebody without bail or whatever it may be. Is there any conversation about that?
Yeah, no, we did hear that was a concern, but I am trying to remember if this was in testimony, but I think it was in testimony that we asked Judge Treadwell about this, but it may have been an offline conversation that I had with Judge Zoney or Judge Treadwell, but I think it was in testimony saying that really shouldn't be considered a problem. Exactly why you'll have to ask judges, because I can't recall exactly the rationale.
All right, thank you.
All right, thank you very much. Hello, Judge Treadwell. Sorry I can't stay. I'd love to stay and hear you, but we'll catch up another time.
Representative LeBlanc, for the succinct and accurate description of how the bill works.
All right, well, good, thank you. I think
Thank you. All right, morning, Judge Treadwell. Good to see you.
Good morning, Senators. Thank you for the opportunity to testify, and also thank you for the opportunity to testify remotely. I am presently in the Wyndham Civil Division here in Newfane, a building regularly described by former Judge Wesley as a temple of justice. It is a really remarkable location. I'm here to talk to you about H744. I think that there are various things that I can address for you. First is the reason for this change. The second would be, if you are interested, the work of the Criminal Rules Committee on amendments to Rule 3K. And I can also talk to you generally about the practices and procedures employed by judges when they are on call in the criminal division. I'm not presently assigned to a criminal division court, but I was from September 2018 to September 2025, and I was on call for 7 years. So I have experience in both Wyndham and Windsor County with being on call. I suspect I may have actually received after-hours calls from Senator Hashim while he was with state police.
There were a few times. Yeah.
Yes. But with respect to the proposal here, the provision Rule 3K is addressed at properly setting bail and conditions for persons who've been arrested without warrant after hours, pending initial appearance and arraignment the next business day. I mean, this can be people who are detained for just a short period of time, arrested in the early hours of the morning and seen, promptly the next day at 1 o'clock. But it also can be, people who are arrested on a Friday afternoon and are not seen until Monday. So the key point here is, and the purpose of this rule change is to, one, properly recognize existing practice and correct what I think is a misstatement of the law in the existing rule. And two, to make sure that the judges or judicial officers who are making these decisions have the maximum information available to make the best possible decision as to bail and conditions of release. And it's important, these orders that these courts make after hours are important because they are relevant to protecting the victims. They are relevant to protecting the community generally. They are relevant to ensuring the appearance of persons at court the next day. And also they are relevant to protecting the liberty interests of presumptively innocent people. These are people who actually have not even been charged yet. They've just been arrested for a criminal offense. So the practice varies from county to county. Rule 5B allows the presiding judge in each criminal division to set practices and procedures regarding after-hours arrests. It actually requires the presiding judge in each criminal division to do that. And there are varying practices across the state. There are counties where either the judge or the state's attorney requires that whenever a person is arrested after hours and is not just going to be released on citation in the ordinary course of business, that there must be a call to the prosecutor to discuss the possible charge and bail and conditions of release before there is any communication with the judge. It's worth noting that a number of years ago, actually in 2018, the legislature amended this rule to specifically require that law enforcement prepare and complete an affidavit, a charging affidavit, to be provided to the judge before any contact was made with the judge. So there has always been this requirement for at least 8 years, almost 8 years now, that an affidavit be prepared. What we're talking about here is additional information from the prosecutor that might be relevant, in fact, frequently is relevant to the decision regarding bail and conditions of release. A critical example of this, for example, is the actual charging the decision that is going to be made. Law enforcement makes a recommendation as to the charges that they believe are that they have probable cause for. That is not binding on the prosecutor. The prosecutor independently reviews the facts as set forth in the affidavit and makes a charging decision. But the actual charging decision makes a critical difference in what decisions can be made regarding bail and conditions. For many years, and as I understand it may come back, expungible or sealable offenses were subject to a $200 bail cap. So if a decision is made by the prosecutor to charge an expungible offense, the cap would be $200, even though the facts might support a different offense that is not expungible. Additionally, there are certain offenses, felony crimes of violence, for which persons can be held without bail. And there may be cases where law enforcement believes that the facts support a charge of a felony crime of violence, but the prosecutor's office may choose to charge it as a misdemeanor or some other felony, and therefore the defendant would not be eligible to be held without bail. It is important for the judges to know and understand this charging decision when asked to make overnight decisions about bail and conditions. Prosecutors, particularly in the smaller counties, may have significant history with the defendant and may be aware of information about the defendant that law enforcement is not aware of, and the court should have access to that information. Fundamentally, the purpose here is to ensure that the judges have the best possible information when making these decisions, which are directly related to public safety, victim safety, and the liberty interests of the persons who are being charged. So that's the purpose.
If I could interrupt real quick.
Sure.
I understand why the charging decisions, why it makes sense. But conditions of release, for example, why would that be relevant in this context?
Well, it's so bail is a condition of release. So it's is the state going to be requesting bail, for example? I think is relevant. The point of bail is to ensure appearance. There may be situations where there could be reasons to believe that a person might be a risk of flight, but ultimately the calculus is that they are not a risk of flight. There are policies that states' attorneys' offices have regarding bail and conditions of release. Law enforcement is not necessarily required to be familiar with those or understand those. So it's my view, and I think the view of most judges, and certainly the view of the Criminal Rules Committee, that it is important that a prosecutor weigh in on a recommendation regarding bail and conditions of release. I mean, conditions of release significantly affect liberty interests. People are removed from their homes. They're not allowed to go places. They're placed on curfews, at least temporarily. It seems that to me that the court should have the maximum possible information and understand what the state will be recommending. Understanding the information will be incomplete at this stage, but understanding what the state will be recommending before setting bail and conditions overnight.
Thank you.
Further questions at this point? I can provide you some history of where criminal rules is with the process, if that is helpful. As I said earlier, this rule was amended by statute in 2018. There was then an emergency amendment by the court, I think that same year, because there was a lack of clarity in the statutory enacted language as to whether an actual charging information had to be provided to the judge overnight. That was cleared up by emergency amendment by the court. Then the subsequent legislative session in 2019, the existing language regarding the affidavit or sworn statement must indicate the crimes to be charged by the arresting officer was added. And it's that language that we are trying to address, because that's not an accurate statement of the law. Prosecutors charge, not law enforcement. And then the additional language very similar to 744 was one of several options that the Criminal Rules Committee considered, there were three options. The option like this, which requires requires that it says that a judge may require the prosecutor to provide a discharging decision and may require them to provide bail and conditions of release. Another alternative was that they must provide a charging decision and may provide recommendation regarding bail and conditions of release. And the final option was a must, so they had to provide both. The committee went with the middle option, must provide a charging recommendation and may provide conditions of release. That was a proposed rule that was sent out for comment. There were no comments received by the Criminal Rules Committee from state's attorneys, VSEA, deputy state's attorneys, as part of the ordinary course. The matter came before the Legislative Committee on Judicial Rules, at which point comments were submitted to the legislature, at least initially by deputy state's attorneys. And there was a request that because it was a proposed rule, the committee considered it further. The legislative LCJR did not take formal action at that time. The Criminal Rules Committee met in February. At that point, we had specific comments from both state's attorneys and deputy state's attorneys. I had solicited comments from the defense bar as well. I didn't only want to hear from prosecutors. The Defender General's Office and the private bar did not submit any comments. The Criminal Rules Committee met in February and concluded that we would stick with the language we already had, which was the must-may option. Senator Sheem raised the question of work product and whether the language here implicates work product. It is my perspective that it does not. All it requires is a statement as to the charge to be filed, not the thought process of the prosecutor in making that decision. Similarly, with respect to bail and conditions of release, it doesn't require that the prosecutor's thought process be included. Fundamentally, this is obviously an initial decision based on information available during the overnight hours, not the full decision that would be made by the prosecutor at the time that charges are filed, if charges are filed. So after the committee met, the House moved H744 further. I, as the chair of Criminal Rules, have held off on transmitting the proposed rule from Criminal Rules to the court for further action, pending to see what the legislature does, because I don't think it makes any sense for the judiciary to act if the legislature is going to act. And that's where the process is currently. Criminal Rules is holding its draft pending legislative action.
Thank you. Judge, I do have one other question that I'm wondering if you could walk through how you would anticipate this happening. So let's say on a Sunday, middle of the night, Sunday, prosecutor is, puts in the affidavit that, the police officer puts in the affidavit that there's going to be a certain bail amount requested at the initial appearance, but then at the initial appearance, after preparing in the morning, the prosecutor realizing that they're actually going to ask somebody to be held without bail. What can you describe how the court would handle a difference between what is being asked at the initial appearance versus what is being asked in the overnight phone call? Sure.
And I have significant experience with that, where I have received overnight phone calls. There has been a recommendation for bail. And then the next day at arraignment, I've had a different recommendation from the prosecutor, sometimes higher, sometimes lower. I mean, I understand that it's, and I can only speak for myself, but I understand that the information that is available in the middle of the night is not complete, and that additionally, facts may have changed in addition to new information becoming available between the time the after hours call was made and the time when the person appears before the court for their initial appearance and arraignment. I don't believe that the overnight decision is in any way binding on the court. I have had situations where there has been an after hours request to hold someone without bail, and then at arraignment, there is no request to continue detention and no request for bail. Obviously, that at some level is concerning, that someone may have been detained unnecessarily, but it doesn't mean that I'm not going to strongly consider the state's recommendation in those situations. Similarly, there have been situations, there are rare situations when an individual is released on a citation and appears the next day, and there is a request for bail. That does occur, and in some circumstances, it may be appropriate to set bail. By statute, if it's a misdemeanor offense, that can't happen. If a person just appears on a citation, bail can't be set. But there have been situations, and I can think of one fairly recently, where an individual appeared on a citation and was subsequently detained.
Thank you. Committee, any questions for Judge Gridwell? Judge, do you have any further comments or suggestions, recommendations for this language?
I think the language as passed by the House is an accurate statement of existing law and the existing authority of judicial officers to basically require that information be provided that they feel is necessary to make these important decisions after hours. So I don't think I have any suggestions to the language to add to the or change the language at all.
Thank you. Okay. Okay. Thank you, Judge. We'll be hearing from some other folks in this, and then we'll go through the process. So yeah, thank you for taking the time to testify.
Happy to do it. And if there are further questions or further issues come up, I'm happy to appear again before the committee. Thank you all. Have a good day.
You as well.
Thanks.
All right. So we don't have ledge counsel on the agenda, I believe, but we should still hear from ledge counsel because we didn't. Yeah, yet. So right. If you want to join us, Eric. So I think we got a pretty clear walkthrough on the bill, but if there's additional information you want to provide us or any questions that you think we should be contemplating with this, floor is all yours.
Sure. Thank you. I want to give Eric Patrick for the Office of Legislative Counsel. Here to talk about H744, inactivating the procedures for release after arrest. I think, as Senator Hashim was saying, you probably heard already pretty much substantively how the bill works. The only couple of additional pieces of background I might provide would be that you'll see the language, two pieces about specific references in the language. Specifically says that procedures and standards established by the presiding judge of each unit pursuant to Rule 5B may, and that was what Judge Treadwell was referring to, that's line 16, may require that the affidavit or sworn statement include the charge or charges that the prosecuting attorney intends to file, and may, that's also line 17, and may require that the affidavit also include any conditions of release, including bail. So you got those two things. I think if I heard Judge Treadwell correctly, he was mentioning that during the rule that was first proposed by the court, which was reviewed by the Judicial Rules Committee, that first May on line 16 was a shall. So that's the difference substantively, that the first in this proposal passed by the House, it's may in May rather than shall in May. So two things about that. First of all, it says presiding, this is saying that these procedures and standards established by the presiding judge of each unit may require. So just so you know, that fits in with what Rule 5B currently does require. For the first sentence of Rule 5B of the Rules of Criminal Procedure specifically says the presiding judge of each unit shall, so that's a requirement, shall establish procedures and standards by which persons arrested with or without warrant other than during normal business hours may be released pending appearance. See, so each judge, each presiding judge in each unit has to establish, because that's a shall, these standards and procedures. So what the basic thrust of the bill is that, well, okay, the judge has to establish those under this rule already, right? These procedures and standards. And the rule says, all right, when you're doing that, those procedures and standards may also require that the affidavit or sworn statement include the charge that the prosecutor is going to file. And I think that Judge Trevor was saying that reflects current practice as well. So that's just so you have a little bit of a grounding in what is in Rule 5B currently. The second point about this, it's a little unusual. You may have noticed the effective date here. So there's a reason for that. And that, as Judge Treadwell was also alluding to, this has been the subject of a lot of back and forth between the legislature and the court. And the court, the Rules Committee at least, met in February. Last posture that Judge Treadwell indicated was that they were going to stick with their approach at that time, which would have been on line 16, a shall, not a may, different than this. So the idea here was that the intent of the bill was that whatever the court decides to do in the meantime, this would supersede it. See what I mean? And the reason for that is because promulgation dates for judicial rules these days, the next one coming up would be July 1st. It's twice a year, December 31st, or sorry, January 1st and July 1st. So the idea would be that, well, if the court had decided to go ahead and promulgate a shall instead of a may on line 16, the intent was that this would control, because this would be effective one day later. See what I mean? However, I understood from what Judge Treadwell just said was that that may be moot because as he indicated, they're going to hold off on that rule and wait and see what the legislature does, because he thought that it didn't really make sense for them to make a change if the legislature was going to make the same change or make a different change.
I mean, if that's okay, I see what you're saying. Then, I mean, if they're holding off, then I wonder if we would just want to make it effective upon passage. That just makes things a bit more efficient.
I think mechanically it works either way. So it's just totally up to the committee.
Did you have a question?
Eric explained it. So July 2nd is a Thursday, a random Thursday. And I was like, why did they pick that? But it makes sense that they were trying to wait out that July 1st.
That's right.
Yeah. Okay, so we'll hear from the SCDA, state's attorneys and defenders for this one. Did the House hear from anybody else aside from those three that I just listed?
Not that I'm aware of, but in case I'm missing somebody, you might want to ask Henry double check the witness list. But I think those were the folks that I recall.
Okay. All right, sounds good. So we'll do that. And Emery, did you make a note for those three folks, three organizations, and we'll figure it out the next week? Sort of speak on the next. All right. Any questions for Eric? All right. Thank you, Eric.
You bet.
You guys are right here.
Sorry.
Looks like great.
Yep, it does look like this. Okay, all right, so we can break it open then, and we'll come back and pick up 849.